The federal marshals were already in position. That detail alone should tell you everything about what happened inside that courtroom. Because the federal judge, sitting across from FBI Director Kash Patel, had run out of patience, and he wanted Patel to know it. What the judge said next reportedly made Patel visibly crumble in real time, and when word of it leaked out of that room, it sent shockwaves through Washington that are still reverberating right now. No friendly Republican senators throwing softballs, no 5-minute time limits to hide behind. This was a federal courtroom, and the man wielding the gavel answers to no one except the Constitution and the appellate courts above him. Sources with direct knowledge of the proceedings say the judge's message to Patel was stripped of any diplomatic language. Produce the documents. All of them. By the deadline. Or the marshals standing in this room will take you into custody. Today. On the spot. But here's what makes this moment truly staggering. The documents at the center of this confrontation aren't just any files. Critics allege they contain the full picture of what the FBI knew, and what it chose to bury, about Jeffrey Epstein's network of powerful associates, including, reportedly, material connected directly to Donald Trump, every delay tactic used, every legal privilege asserted, every procedural objection filed, and the judge, according to sources, told him flat out, every single one of those arguments has been considered and rejected. You are out of moves. So how did it come to this? How does the director of the most powerful law enforcement agency on earth end up standing in a courtroom, being told he faces immediate arrest? This was a slow-motion collision between a man who believed his position made him untouchable and a federal judiciary that was done pretending otherwise. Patel took over the FBI with a reputation built entirely on loyalty to one man. And according to whistleblowers who have since come forward at significant personal risk, that loyalty became the organizing principle of his entire tenure at the Bureau. Sources inside the FBI say agents were redirected, investigations were narrowed, and certain files, the Epstein-related materials that Congress had been demanding for months, were treated as something to be managed, not released. And then a whistleblower handed congressional investigators a specific internal memo, dated 4 months ago, in which a senior FBI official wrote that certain Epstein-related file categories required director-level sign-off before any external disclosure. 4 words that, legal analysts say, place Patel's fingerprints directly on the suppression. What the court subpoenaed wasn't vague or ambiguous. Records that, according to legal analysts watching the case, would reveal precisely what instructions Patel gave to his agents, and whether those instructions pointed toward accountability or away from it. Month after month, those documents didn't come. New objections appeared. National security concerns materialized. Executive privilege was asserted over materials that legal scholars say cannot legally be shielded by executive privilege. The judge watched all of it. And sources say his patience had a definite endpoint. What pushed it over? According to sources close to the proceedings, it was a single email chain, subpoenaed separately through a parallel civil case, showing Patel's office was aware of the court's document requests in real time and was actively tracking the countdown, not to comply. To calculate the minimum they could surrender without triggering sanctions. The judge reportedly held that email chain in his hand when he issued the final warning. Now here's what almost nobody is talking about yet, and this is the part that should make everyone stop and pay attention. The contempt power a federal judge holds is not symbolic, it is not rhetorical, it is immediate, and it is physical. Civil contempt doesn't require a jury, doesn't require a lengthy trial. The judge makes 3 findings. A valid order exists, the person can comply, the person is refusing, and the marshals move. Patel could walk into that courtroom as the director of the FBI and walk out in handcuffs as a federal detainee. Sources say the judge made this unmistakably clear. And reportedly, for the first time in his tenure, Patel crumbled. Emotional. The composed, combative official, who had sparred with senators for hours across 2 consecutive days of congressional testimony, looked, according to those present, like a man finally realizing that the legal architecture he assumed would protect him had collapsed completely. One source in the courtroom described his hands as motionless on the table, the kind of stillness, they said, that doesn't look like composure, it looks like shock. But wait, because the jail threat is only one layer of what Patel is now facing, and critics allege the other layers may be even more devastating long-term. Federal judges possess the authority to refer attorneys for professional discipline. Patel is a licensed attorney, and a finding of contempt, of willful defiance of a court order, is among the most serious grounds for disbarment proceedings, permanently. Not suspension, permanent revocation of his law license. Sources familiar with the proceedings say the judge explicitly mentioned this possibility, which means Patel isn't just risking his freedom, he is risking his entire professional identity. And then there is the criminal contempt dimension, which reportedly no one in Patel's inner circle had fully wargamed before this hearing. Criminal contempt is not designed to coerce compliance. It is designed to punish defiance. It produces criminal charges, fines, jail sentences that do not disappear simply because the person eventually decides to cooperate. Sources say federal prosecutors connected to the case have been monitoring the proceedings closely. A criminal contempt referral would make Patel a criminal defendant, being prosecuted by the very Department of Justice he nominally helps to lead. So what happens next? That question is hanging over Washington right now like a storm that hasn't broken yet. Patel has a choice. And critics allege it is the worst kind of choice, one where both paths lead somewhere he cannot come back from. If he complies and releases the documents, the contents of those files become public. Whistleblowers who have spoken with congressional investigators say the materials include detailed FBI records of communications between Epstein's operation and individuals at the highest levels of American power. Sources say those records would answer questions that have been circulating since Epstein's death, questions about who knew, who participated, and who used their influence to ensure the investigation went nowhere. If those documents contain what critics allege they contain about Trump, Patel isn't just releasing files, he is detonating a political device that cannot be undetonated. And sources say one specific document inside that tranche has become a major focus for congressional investigators. According to a source familiar with a partial index of the withheld materials, the document directly links internal decision-making at the highest levels of the Bureau to the handling of Epstein-related records. One investigator reportedly described it as the kind of record that ends careers the moment it becomes public. And if he refuses, if he decides that loyalty to Trump is worth federal incarceration, then the FBI is led by a director sitting in a detention facility, fighting contempt charges, facing potential criminal prosecution, and staring down disbarment. The institutional damage to the Bureau in that scenario is, according to former senior agents who have spoken on condition of anonymity, almost impossible to overstate. The FBI's operational effectiveness depends entirely on public trust. When the man who carries the highest badge in the organization is the subject of a contempt arrest, that trust doesn't erode, it collapses. Sources inside the Bureau say morale among career agents is already at a breaking point. Agents who dedicated decades to the institution, who built cases, protected sources, put dangerous individuals behind bars, are now watching their director treat a federal court order the way an ordinary citizen might treat a parking ticket, only with far larger consequences for everyone beneath him. One longtime agent, speaking anonymously, reportedly told colleagues in an internal communication that has since been shared with congressional investigators, "This is not what we signed up for. This is the opposite of what we signed up for." The broader context surrounding this confrontation is something critics allege the administration desperately does not want the public connecting, because the pattern, once you see it, is unmistakable. The Attorney General was reportedly under investigation for document handling. The FBI director is now facing contempt charges and potential arrest. Multiple senior Justice Department officials are believed, according to whistleblower accounts, to have been aware that Epstein-related materials were being managed rather than released. And every layer of obstruction that gets peeled back reveals another layer underneath it. Sources familiar with the congressional investigations say lawmakers on both sides, including several Republicans who are not talking publicly, have seen enough to understand that what Patel has been protecting is not national security. It is proximity to power. And here is what the coming deadline makes so extraordinary. The Epstein files are scheduled for broader release imminently through separate legal and congressional channels. The court deadline for Patel's compliance arrives at essentially the same moment. Multiple accountability streams, converging simultaneously. Critics allege this convergence was not accidental, that the timing reflects the reality that the legal system, however slowly, has been closing off every avenue of delay one by one. And now the avenues are gone. The judge said so explicitly, according to sources. Every legal mechanism for postponement has been exhausted. Every argument has been considered and rejected. What remains is compliance or arrest. No third option exists. What does this mean for Trump? Directly and severely, according to political observers across the spectrum. Patel was placed at the head of the FBI for one operational purpose, to ensure the Bureau's investigative machinery pointed away from the man who appointed him. That strategy reportedly worked until a federal judge decided it wouldn't. If Patel is arrested, the political catastrophe is immediate and irreversible. An FBI director in handcuffs, in federal custody, fighting contempt charges. If Patel complies, the documents he releases may accomplish what 3 congressional hearings could not, creating a documented, verified, legally compelled record of what the FBI knew and what it chose not to pursue. Sources say neither scenario ends well for the man who made Patel's appointment possible. The Epstein dimension of this is what gives it a moral gravity that transcends ordinary political controversy. This isn't fundamentally about budget documents or personnel files or interagency memoranda. The records at the center of this confrontation concern one of the most disturbing criminal enterprises ever investigated by American law enforcement. Epstein's operation involved the systematic exploitation of vulnerable individuals, facilitated by wealth, protected by influence and, critics allege, ultimately shielded by institutional cowardice at the highest levels of federal law enforcement. Whistleblowers who cooperated with federal investigators say those answers are in the files Patel has been fighting to conceal. The judge, reportedly, told him those files belong to the American people, not to the FBI director, not to the president who appointed him, to the American people. The clock is running. The deadline is not negotiable, according to every source who has described the judge's language. The marshals are not a metaphor. And Kash Patel, the man who walked into the FBI confident that loyalty was its own kind of legal protection, is now discovering what federal judges have been telling powerful defendants for 200 years. In this room, the law is the only protection that matters. So here is the question nobody inside the Trump administration seems to have a clean answer to right now. If the director of the FBI, the nation's chief law enforcement officer, goes to jail for defying a court order designed to uncover the truth about one of history's most notorious criminal networks, what does that tell us about who he was actually working for? And should a man facing contempt charges, potential disbarment, and the possibility of criminal prosecution be allowed to keep his badge for even one more day? Drop your answer below, because the people defending this, and you know exactly who they are, need to hear from you directly.